All right, welcome back. This is the Energy and Carbon Management Commission. It is June 26th. It is 12:10, and we have one more matter before us on today's agenda. That is deliberations on docket 2409-00228. Before we move to that, Commissioner Oath, I know you're going to be off visualization, but are you with us?
I am, yes, thank you, Mr. Chair, and I apologize for those who aren't aware. I just am experiencing a power outage at my home, and so I am participating by my phone, but I'm trying to save some battery on my phone, so I'm keeping my video off.
So sorry, but we totally understand. Uh, so before we move, I want to ask Hearings Manager Thomas, we do not need to elevate the attorneys because we're just deliberating, but can you confirm they are in attendance?
Yes, Mr. Chair, I can confirm that all of them are in the attendee list at this time.
Okay, and I believe one of the attorneys for KPK is likely to drop to go attend a different matter, and we talked about that yesterday, and that's perfectly acceptable. The deliberations are not needed for the attorneys to participate, but I do want them to be aware of what we're doing. All right, well, we have received a ton of information in this docket. We've held hearings for 3 or maybe even 4 days. It's now up to commissioners to deliberate on the Rule 211 well closure request. And with that, I look to my fellow commissioners to see if someone would like to lead us off in deliberations. All five of us will have a chance to speak. Commissioner Cross, I see you're kind of waving your hand there. Do you want to get us started?
Thank you, Mr. Chair. And I do want to start off before I begin my deliberations. I do want to say a thank you. I know they were recognized as just a small group of many of our great staff at the recent all hands meeting, but I do want to say thank you to our hearing staff again, in particular Angelica Amaro. She stayed up late last night trying to make sure that yesterday's video recording was converted, so I would be able to watch it and make sure that I got some of the citations and comments correct. So I appreciate going above and beyond to stay up and help with well beyond work hours to make sure that we have the necessary information. So thank you for that. I will let everybody know that I do have quite a bit of information to go through here. So I'll try and be as succinct as possible. But I want to make sure that I talk not just about the 211 rule, but some of the attendant discussions that happened during this. For an introduction, I want to make sure that, as always, we must begin with the plain language of the legislation and or the rule. Here, Rule 211 sounds relatively straightforward, but it is not. The rule is based on prior COGCC Rule 208, which allowed the commission to require wells to be plugged and abandoned if no longer used or useful. As with many of our rules, this regulation was updated in accordance with Senate Bill 19-181 and added the ability to require plugging and abandoning if reasonable and necessary to protect or minimize adverse impacts to public health, safety, welfare, environment, and wildlife resources. There was a lot of testimony during this hearing about what qualifies as used or useful. So again, we look to our rules. Our regulations define used or useful as a well, location, or facility that is currently being used or has an identified future beneficial use, which may be indicated by, among other things, A, production trends for the well, B, plugging and abandonment, remediation, and reclamation costs in relation to the well's gross revenue generation, C, failure to use or develop a facility, D, remaining economic viability, or E, other relevant evidence. I will get to each of those factors shortly, but in the meantime, I think it's important to note that in statutory and regulatory interpretation, you must give meaning to all the words in the rule. Here, the factors identified in used or useful must be given appropriate consideration. KPK has argued at times that certain liabilities, i.e. remediation and plugging and abandonment, should not be considered in the economic viability of the well. That simply cannot be the case. However, the operator would like to characterize or account for liabilities The rules are clear that remediation, reclamation, and plugging and abandonment costs must be taken into account in our evaluation under Rule 211. Next, I want to talk about reasonable and necessary. First, I must point out that Rule 211A regarding plugging and abandonment relies on the phrase reasonable and necessary, but 211B regarding location or facility closure only says necessary. Given the inclusion of and rather than or, the plugging and abandonment standard would not be lessened, but additive. Similarly, 211A indicates that plugging and abandonment must be reasonable and necessary to protect or minimize adverse impacts, while 211B indicates closure must be necessary to protect and minimize adverse impacts. Setting aside the difference between each subsection, while reasonable and necessary is not defined in our rules, the inclusion of reasonable and necessary, and particularly the necessary component, is critical to my evaluation and decision-making. While not enforceable or technically part of the rules, I do look to the statement of basis and purpose for any guidance on this rule, particularly given the limited application of this rule in the past. As explained in the statement of basis and purpose, this rule has rarely been used in the past, and the Commission intends to continue to use it only in rare instances. Indeed, the Commission does not intend for a 211 hearing to occur at every instance a well is shut in or a corrective action is required. Such a broad application is surely not what was intended and highlights the importance of reasonable and necessary described above. Our 600, 900, 1000, 1100, and 1200 series rules already provide requirements on safe operations, necessary measures to protect public health, safety, welfare, environment, and wildlife resources, and reclaim sites, and the regulatory steps for addressing and remediating spills and other environmental hazards or instances. Similarly, our rules provide for the ability to shut in wells as necessary for, amongst other things, to perform maintenance or repairs. Therefore, it is clear that mandating plugging and abandonment pursuant to Rule 211A or facility location closure pursuant to 211B should be reserved for those situations where our rules alone are insufficient to address the on-site situation that has led to the application. Put more succinctly, where a requirement to plug and abandon or close is reasonable and necessary to protect or minimize adverse impacts. Finally, as always, it's critical to highlight that the applicant bears the burden of proof in this matter. I applaud the applicants here for taking the step to bring a 211 application that has not been previously heard by this commission before. I understand and appreciate Dakota and Frederick's frustration with the pace of remediation, the pace of relevant judicial review actions, and the difficulties to allow and encourage development within their jurisdictions because of the wells at issue. While I share many of the same frustrations, I must still hold them to the same standard of burden of proof that I do for any other applicant in any other manner. As a roadmap, I'm going to provide some overarching general thoughts on some topics about which we received testimony in this hearing before providing opinions on a well-by-well basis. Unlike financial assurance or previous KPK hearings concerning remediation efforts for a group of wells subject to a compliance plan agreement, I think a well-by-well approach here is necessary given the plain language of the rule. Further, these wells do not operate as a group or unit and must be evaluated in the same manner. To begin with, I want to talk about adherence to some of our rules. I'm going to start with what can best be characterized as dicta. I'd be remiss here not to address KPK's failure to adhere to ECMC rules. KPK admitted throughout this hearing that it has repeatedly failed to file requisite remediation updates and reports. It has admitted that it has failed to conduct requisite mechanical integrity tests on shut-in wells. It has admitted that it has repeatedly failed to file requisite Form 27s as part of the remediation process. These failures have led to numerous sites failing to be remediated for years. The unabashed admission of failure to adhere to our rules, to which all operators are subject in this state, is a glaring depiction of this company's contempt for responsible oil and gas development. Rather than follow the rules, KPK makes excuses. For example, Mr. Peterson testified that ECMC simply treats KPK differently than other operators, but nothing could be further from the truth. As Deputy Director Duranlo explained in his testimony, staff has denied hundreds of Form 27s this year alone for operators other than KPK. Those other operators expeditiously work to resolve the issue and resubmit the form. KPK does not. And the stated reason for failing to do so? Believed futility. Moreover, throughout this hearing, KPK, mainly through the questioning and argument of Mr. McGowan, has asserted that just because forms haven't been filed or MITs have not been conducted does not mean that the applicable wells do not have mechanical integrity or remediation work has not been done. While I'm not prone to melodramatic or overblowing characterizations, this is one of the most disreputable arguments I have ever heard. And I do not mean that as hyperbole. As Mr. Duramo explained, ECMC is the arbiter of whether remediation work is complete, not the operator. And if the appropriate information is not submitted to ECMC, there is no way to know whether the work has been completed or the results are accurate. While KPK may argue that just because forms aren't submitted doesn't mean work hasn't been done as required, Mr. Prescott put it well. The opposite may be true. If the information isn't submitted, you can't know that it has been done as required. This pattern of disregard for regulations to which every operator in the state is subject, is not new and demonstrates why this commission has previously found KPK has committed widespread, systematic, repeated violations of ECMC rules. Its practices present threatened and actual adverse impacts to public health, safety, and welfare, the environment and wildlife resources, and why this commission has previously imposed millions of dollars in fines, suspended their certificate of clearance, and threatened to revoke their license to operate if KPK fails to pay its fines and get into compliance. Such rulings are not at issue here today. Rather, those are currently before the Colorado District Court on judicial review. But the findings demonstrate the agency's efforts to deal with KPK's operations, which is again contrary to Mr. McGowan's closing statement, in which he said the commission has not taken any action to seek injunction, or cease and desist orders because no such order is necessary as KPK has completed its remediation projects. The above findings and orders show that ECMC has taken actions and has determined the remediation activities are not complete. A couple final notes on compliance before I specifically move to substantive issues at hand. First, mechanical integrity tests can be completed here. Ms. Byrne, ECMC's engineering manager, testified to this fact. Indeed, the 903 rules provide exceptions to the venting and flaring prohibition that was raised, including maintenance and repair activities, liquids unloading, braiding head testing, and the like. Moreover, KPK could always seek a variance from the 901A or 901A order to comply with the rules. Rather than using any of these options, KPK instead seeks to place blame elsewhere yet again. Second, I want to correct the record on whether KPK was required to apply for and or report its prior refracturing operations. As staff experts testified, since at least 1998, our rules have required these steps. Yet KPK conducted more than 40 such refractures while only reporting on 3 such instances. This again goes to the pattern of disregard KPK has for state rules. It is not a recent phenomenon, but something that has been happening for years. And Ms. Clark's testimony that there is no such rule is simply wrong. If a witness does not know the answer to a question or has not done the requisite research to confirm an answer, it is best to say so, rather than to affirmatively claim such a rule doesn't exist based on the fact they didn't find the rules in place before 2012. This is particularly true for a witness that was allegedly put forward to testify as to economics, but voluntarily provided to provide testimony as to the existence and scope of regulations. I want to start with the used or useful standard and kind of talk about it in general aspects first. As mentioned previously, the used or useful standard predates the mission change rulemaking. In fact, the phrase has been used since 1954, but was not defined until the recent financial assurance rulemaking. As Mr. McGowan testified in his closing, the definition of used or useful means a well or location or facility that is, quote, currently being used or has an identified future beneficial use, end quote, and provides 5 factors to consider in making that determination. While on its face, the or in used or useful suggests a currently producing well, regardless of production, satisfies the definition, such an outcome is illogical. If a minuscule amount of production was sufficient to avoid forced plugging and abandonment, operators could theoretically avoid plugging and abandoning liabilities for years. Therefore, some ambiguity exists, and we must look to the statement of basis and purpose for clarity. In looking at the statement of basis and purpose, it is clear that KPK's interpretation is incorrect. Use alone does not meet the standard. The 5 factors to evaluate are applicable to the combined phrase. As the statement of basis and purpose explicitly states, both components of the definition are important, and they are intended to be inclusive, not mutually exclusive. That is why the factors are described as a non-exclusive list of factors that the commission has determined are relevant to identifying whether a well continues to be used or useful. It is clear that the factors apply to used just as they apply to useful. Thus, a used well may not be a useful well. I want to next talk about some of the 901A orders because I think that's pertinent to a lot of my decision making here as well. The existence of 901A orders here make an already complicated application even more muddled. As testified to by staff, the 901A orders were issued, at least in part, in hopes that this would speed up remediation efforts by KPK, which has not been the case. Again, KPK's failure to adhere to ECMC rules and expediently remediate spills and other issues is frankly abhorrent and remains the topic of numerous judicial review actions currently in the district court. Looking at the issue at hand, the fact that many of these wells are shut in does indeed show that those wells are not currently used. However, it's noteworthy that for many of these wells, not being used is a consequence of our order, not because of KPK's business decision or perhaps the economic viability of the well. Therefore, I don't think that such a consequence is appropriate for the determination of used in this situation. Put more succinctly, our order to shut in wells should not mean the well is not used. Next, I want to go into the valuation issues attendant to used or useful. A significant portion of this hearing was focused on the competing expert testimony from the parties regarding the valuations and economic viability of the wells in conjunction with the used or useful standard. Before addressing my conclusions on used or useful for the wells at issue, I want to address some thoughts on these valuation disputes. First, I want to talk about comparable transactions. Initially, there was quite a bit of testimony regarding the appropriateness of the comparable transactions used by KPK. Specifically, whether getting developers that now own the surface, whether they're being forced to agree to plugging in abandonment agreements that were simply, that were done under economic duress. Mr. Mailer for KPK argued that the agreements were simply a demonstration of fair market value, the price a buyer was willing to pay. I think there are inherently problems with both sides of the argument here. Generally, while fair market value is established by the price paid, valuation analyses are usually determined in an open market. Here, there is no such open market, but only a single buyer available, the surface owner or developer, which does not invalidate the comparable transaction valuation, but does create concerns with those analyses as determinative of value. Similarly, I have concerns with using the plugging and abandonment agreements as a determinative factor in valuation because of the undefined variables that factor into those agreements. Specifically, the consideration paid presumably covers both the plugging and abandonment cost as well as the foregone value of the mineral resources extracted from that well. That liability and the well value are presumably not identical in every circumstance due to potential production values, work required on the well, potential remediation costs, varying plugging and abandonment and overflow mine removal costs, etc., rendering a value that may include, in part, the economic value of the well. Moreover, such an agreement cannot be determinative of value for each well, as some of the wells at issue may not be potential candidates for plugging and abandonment agreements. Without KPK providing detail on what the economic value of each well is versus the plugging and abandonment remediation costs, and without providing detail as to which wells would even allegedly be properly valued by a plugging and abandonment agreement, I do not believe such values are determinative. Simply put, a well sitting idle, waiting for someone to pay KPK to plug and abandon it is not used or useful because KPK may have a benefit from being paid to plug it. On the flip side, I do not buy into the argument that the developers were subject to economic duress. Not only does this assertion overstate the definition of economic duress, it is also important to note that developers here are sophisticated parties and knew, or should have known, that the plugging and abandonment of these wells would need to happen before development can occur. Without evidence that KPK somehow hid the existence of these wells, I cannot conclude that these developers were somehow being held over a barrel. Finally, I also take issue with the statement made by Mr. McGowan in his closing that comparable transactions are, quote, the most relevant evidence in any fair market value inquiry, end quote. While assessing comparable transactions is a valuable valuation tool in determining relative value, it is not the only tool, particularly where there are unique factors or distinct differences between transactions, such as here, where remaining value will differ in each transaction. That is why there is also replacement or cost value approach, and income or intrinsic value approach to valuations, the latter of which includes a discounted flow analysis as one methodology, as was done by the parties here. A valuation is then determined by assessing the different methodologies and the reasonableness of the outcome for each, with the conclusion sometimes being somewhere in the middle. Bottom line, I do not find that the comparable transactions here is the most relevant and reliable evidence to determine value. Moving on to the other valuation methodology, I have some broad points on the discounted cash flow analysis. First, I had serious concerns with all the valuations provided. For the applicants, I do question the costs, specifically the field and operating costs utilized. While I do believe that Ms. Lencioni did a good job highlighting uncertainty and errors in KPK's discounted cash flow analysis, such as potentially overlapping and difficult to identify costs, lacking information related to refracturing and CCUS uses, I do find some validity in KPK utilizing its own operating costs rather than Ms. Lencioni applying costs to groups of wells. Again, this is ultimately a well-by-well determination. Unlike the financial assurance hearing, during which the commission needs to assess third-party costs to plug and abandon or remediate, KPK's costs here, although suspect, are appropriate as we seek to determine if the well is economic for KPK. For KPK, I have concerns with proving the costs. As Ms. Lencioni highlighted, and as Commissioner Messner inquired about, the inability to identify costs makes valuation difficult, if not impossible. Additionally, I have serious concerns with KPK's desire to remove certain costs, such as plugging and abandonment or remediation. At times, witnesses refer to these costs as capital expenditures or unavoidable liabilities, such as Mr. Kaufman testifying that such costs should not be counted against the future economics of the well. Not only is disregarding such liability illogical, it is contrary to what evaluation of this rule requires. Not only does the evaluation of used or useful require assessment of production trends of the well, but the cost of P&A, remediate, and reclaim the well, quote, in relation to the well's gross revenue generation. The statement of basis and purpose is clear that this is what is used or useful means. Quote, when the cost of conducting these required activities exceeds the revenue actually generated by the well, it is a strong indicator that the well is no longer used or useful. End quote. The argument that considering P&A cost is an industry standard is simply irrelevant here. Perhaps my greatest concern with KPK's costs, however, is that their own witnesses could not explain why their proposed costs would bring production back to the levels consistent with their proposed decline curve. Mr. Sura asked Ms. Clark how minimal production over 8 years would jump, and she answered that there were, quote, simple downhole issues. I further inquired about how she knows what the issues are and how she knows that the normal operating costs would be sufficient to return production to normal, and she could only say that she isn't aware of anything that would require a larger workover. Unverified assertions such as this are nugatory, and I do not find this testimony credible, especially without MITs being conducted or without such repairs having occurred already. I also have issues with both sides' valuations. There was a lot of back and forth about the amount of time used for production timelines. KPK, for example, discussed that Ms. Lencioni only used 10 years of data, while KPK used 25 years. However, KPK has historical data and could have easily used more than 25 years, as many of these wells were drilled in the 1970s. And certainly after the initial production phase, which is typical for most discounted cash, for most DCAs. Indeed, in his closing, Mr. McGowan criticized Ms. Lencioni for only using a 10-year decline curve despite wells being used for decades, but KPK doesn't use the full production timeline either. As an aside, there was a lot of discussion about the golden rule of DCAs, the decline curve analysis, and whether or not new trends could occur, and the angle of decline was criticized by both parties. I'll note, however, that I don't ever remember seeing a decline curve that was a straight line except at the end of the life of a well. I think additional production history from both sides would have been helpful to as well to depict better future trends. The final issue I want to address with respect to used or useful is that of, quote, identified future beneficial use. Here, KPK argues that they have beneficial value in all of these wells because all of the wells can be refractured with a net present value of $74,000. Similarly, KPK argues that there is a potential for enhanced oil recovery and carbon capture and sequestration. In my opinion, KPK has failed to show that these are possible beneficial future uses. Mr. McGowan argued in his closing that such uses need only be identified, not probable. This is not the case. If that was all that was required, used or useful could be met in every circumstance. Indeed, the statement of basis and purpose specifically states that an operator must present relevant evidence indicating the identified future use. That was not done here. I recognize KPK set forth the Netherlands Sewell pricing deck from 2014 on refracturing, but I don't think this provides the requisite evidence to prove the alleged future use. Costs from over a decade ago do not support an argument that KPK wells at issue here will have an additional $74,000 in net present value. There is not well by well analysis. There is no evidence to support that this is a real possibility. Mr. Kaufman testified that previously banks would loan them money to do refractures, but they can't show that they have the funds to do so now. The refractures that they did were approximately 2 decades ago, aside from one done in 2018. And if there was such a benefit to this action, it would have been done. The reason for not refracturing to date is apparently that they are focused on remediation. Again, this is not credible. While they have spent money on remediation, if there was such a benefit to helping pay for remediation through refracturing, or if banks were willing to loan money to do it, they would have. Indeed, in prior hearings and court cases, KPK has indicated they don't have the money to pay fines. They don't have the money to post bonds, etc. To show that refracturing is possible, they need to present evidence that this is something they are considering, they are investigating, and they have taken steps to do. That simply has not been done here. The other identified uses, enhanced oil recovery and CCUS, are even more lacking. KPK testified about potential grants from the Department of Energy and a viability study showing additional oil could be recovered and carbon could be stored. Ms. Clark does not even put potential beneficial values in her analysis. She instead only says there are viability studies. Again, there is no evidence that KPK can do this or can afford to do this. Moreover, the wells simply cannot be used for carbon capture. They cannot show that the wells, particularly in their current condition, would meet EPA rules or our own rules if and when we get primacy. As Ms. Lencioni's testimony on the possibility of CCUS here is credible, particularly the time, cost, and planning required, the need for new wells, and the need for low number of penetrations in the formation. Bottom line, I don't think there is any evidence that a future beneficial use has been demonstrated here, only grandiose ideas. Next, I want to talk about reasonable and necessary to protect and minimize adverse impacts. At the outset, I do also want to note that KPK seems to suggest during their case in chief, as further illustrated by their demonstrative presentation slides, that the impacts of public health must be, quote, serious or significant. Mr. Schwarzenegger specifically indicated that we as a commission have to determine the types of impacts that are necessary to justify a forced plugging and abandonment of wells. This conflates our rules and standard to be applied here. The types of impacts to public health, safety, welfare, environment, and wildlife resources are adverse impacts. Mr. Peterson said it isn't clear what adverse impacts are, but I disagree. Adverse, based on its plain meaning, is an undesired, negative, or harmful impact. This is supported by examining our definition of cumulative impacts, which indicates that cumulative impacts can be adverse or beneficial. Therefore, we can also consider adverse impacts to be the opposite of beneficial impacts. The necessary part of Rule 211 does not refer to a threshold of impacts. Rather, as I discussed previously, whether the plugging and abandonment of a well, or in the case of 211B, the closure of a facility and or location is necessary to protect and minimize adverse impacts. Ultimately, this is not a debate about the severity of impacts. Rather, it's a determination of whether plugging and abandonment is necessary to protect and minimize those adverse impacts. While I do have grave concerns about KPK's pattern of disregarding rules and numerous outstanding remediation projects, I do not find that plugging and abandoning the identified wells is reasonable and necessary to protect public health, safety, welfare, the environment, and wildlife resources. This is for two reasons. First, some of the ongoing remediations are unrelated to the well specifically, whether flow lines or gathering lines. Work needs to be done on remediation without a doubt, but plugging and abandonment of the wells does not solve those problems. Second, and far more importantly for my analysis, I do not think plugging and abandonment is necessary to protect or minimize adverse impacts because ECMC has already taken steps necessary to resolve outstanding remediation issues. Indeed, the issues identified by Dracono and Frederick are the subject of 901A orders, enforcement proceedings, and a compliance plan agreement, amongst others. There are numerous outstanding judicial review actions pending in the district court that may address many of the wells at issue. I asked Ms. Van Dudekam during Frederick's case in chief why they are seeking a 211 order rather than waiting on existing enforcement activities. And she indicated that they are fed up with the delays and trying anything they can. I think her exact words were throwing it at the wall to see what works. I completely understand this frustration, particularly the delay caused by numerous judicial review actions. But unfortunately, this does not demonstrate that forced plugging and abandonment is necessary. As I previously stated, the burden of proof here is on the applicants, and I do not believe that burden of proof has been met with respect to this problem. Finally, I'm going to address my findings on individual wells with respect to the used or useful standard. I'll admit initially I planned on going through each of the wells one by one in each local government's jurisdiction, but I think my analysis thus far sufficiently explains my reasoning I'm about to provide, so I'll try and save some time here. Ultimately, I find that 3 wells are not used or useful and should be ordered to be plugged and abandoned pursuant to Rule 211A. Those 3 wells are the UPRR 43 Pan Am I-25 in Dacono, the Milton Nelson F1 in Frederick, and the Thomas Russell D2 in Frederick. My conclusion for these wells is based on the fact that even KPK's decline curve analysis shows a negative value for these wells. While I have concerns with the DCAs from both parties, again, the burden of proof is ultimately on the applicants. Thus, I did choose to consider KPK's lease operating expenditure amounts, although they are suspect. Even using those amounts, several wells are barely profitable over the next few years if production resumes and if that production is consistent with KPK's projections. Although I'm not convinced that will occur, I'm not convinced the applicant's decline curve analysis is more appropriate. I had many concerns with Mr. Kaufman's testimony, including the desire not to apply plugging and abandonment or remediation costs, his disagreement with the appropriateness of the used or useful standard in connection with efficient operation. However, I do agree with him that some benefit from these wells is beneficial to the overall business here, to an extent. I do not believe that any money coming in, even at a loss on a per well basis, means the wells are used or useful. But some profit can be beneficial both to the business as a whole and to help pay for the liabilities that must be taken into account, i.e. plugging and abandonment, remediation, and reclamation. Some of these wells, even under KPK's helpful assumptions, will not be profitable within several years of production, but for now, I do find them useful. Where there is no profit immediately, the 3 wells I previously identified, our rule is clear that where costs exceed the revenue actually generated by the well, it is a strong indicator that the well is no longer used or useful. Ultimately, I think the grouping of the large number of wells in this applications perhaps muddied the waters. But looking at each well, I think the 3 wells identified are the only ones that meet the requirements of 211A. Again, I sympathize with the applicant's frustrations, and I hope that many of these issues will be resolved soon. But under the confines of our rules, I believe this limited relief is appropriate. So I'll just finish by expressing a very apt quotation by Justice Gorsuch. A judge who likes every outcome he reaches is likely a very bad judge.
Thank you, Commissioner Cross, for the great attention to detail with your analysis with regard to a lot of the information that was put before us. Looking to other commissioners, and Tricia, you can raise your hand or start talking if you want to go. I think Commissioner Messner wants to go next, and then we'll continue down the path.
Thanks, Mr. Chair. Thanks, Commissioner Cross, for kicking us off there. Appreciate the background information. I think a lot of what you utilized in your analysis is similar, I think, to the approach that I took. Some of it's different, however. And so I'll go through my analysis a little bit here as well. Certainly this has not been an easy analysis, and I appreciate all of the information that's been provided by each of the parties. I do want, like Commissioner Cross, to explain my approach to determining the outcome of the wells in question in this matter. And to start out, I want to talk about some of the definitions that I think are important in this review. Certainly the definition that Commissioner Cross highlighted, used and useful, is a essential definition, and so I won't go over that again. But I think there's other definitions that play into this as well. The definition of well, which means an oil or gas well, a hole drilled for the purpose of producing oil or gas, a Class 2 UIC well, a stratigraphic well, and a gas storage well, or a well used for the purpose of monitoring, observing a reservoir. I think the definition of plugging and abandonment is important here because it means the permanent plugging of a well and the removal of its associated production facilities and the abandonment of its flow lines. The definition of remediation, which means the process of reducing the concentration of a contaminant or contaminants in water or soil to the extent necessary to ensure compliance with the concentration levels in Table 915.1 and other applicable groundwater standards and classifications. The definition of reclamation, which means the process of returning and restoring the surface of disturbed lands to its condition prior to the commencement of oil and gas operations. The definition of oil and gas facility, which means equipment or improvements used or installed in an oil and gas location, primarily for the exploration, production, withdrawal, treatment, or processing of crude oil, condensate, E&P waste, or gas, including the use of any heat extracted with processed produced fluids. And then I think, as Commissioner Cross indicated, the minimize adverse impacts definition, which is providing necessary and reasonable protections to reduce the extent, severity, significance, or duration of unavoidable, direct, indirect, and cumulative adverse impacts to public health, safety, welfare, the environment, or wildlife resources from oil and gas operations. And then I think the rules that I believe apply to this proceeding is Rule 503G12B, that indicates that the application by the relevant local government will include a certification that the relevant local government has conferred in good faith with the operator, a certification that the well or wells have been low producing each year for the previous 3 years, and evidence demonstrating that the well is a threat to public health, safety, welfare, the environment, or wildlife resources, or is no longer used or useful. And then as Commissioner Cross indicated, Rule 211, which I won't go through again, which is the plugging and abandonment of wells and closure of oil and gas facilities and locations. And like Commissioner Cross, I reviewed the SBP that was developed both in the mission change rulemaking and in the financial assurance rulemaking for perspective. And it did provide good perspective on a lot of these items. Quoted from page 23, a well or an oil and gas location or an oil and gas facility with or without associated wells is no longer used or useful if it has two core characteristics. First, a well that is not currently being used is not used. Of course, not all wells that are not currently being used are no longer useful. Some wells may be temporarily shut in for maintenance, pipeline capacity issues, or temporary economic considerations or other factors. But if it is not currently being used, it is not used. Second, a well that does not have an identified future beneficial use is no longer useful. The Commission recognizes that there may be scenarios where a well may be repurposed for a use other than hydrocarbon production, such as an injection well, a carbon sequestration well, geothermal well, or geothermal co-production well. The Commission determined that these repurposed uses are beneficial and intends to allow future beneficial use to be considered for the useful determination. Accordingly, if an operator presents relevant evidence indicating that an identified future beneficial use, the Commission may consider such information to identify whether the well continues to be used or useful. Both components of the definition are important, and they are not intended to be inclusive nor mutually exclusive. The Commission recognizes that the used or usefulness of each well is different and in some cases may relate as much to the financial characteristics of the well's operator as actual production trends at the well. Accordingly, the Commission identified a non-exclusive list of factors that it determined are relevant to identifying whether a well continues to be used or useful. First, the Commission determined that production trends are highly relevant in determining whether a well continues to be used or useful. Production is the primary and often only source of revenue from a well. Therefore, declining production over time or zero production is a strong indicator that the well is no longer used or useful. While a well can potentially be recompleted or a different formation is completed in the same well, in general, in the Commission's experience, a well declines in production prior to an operator plugging and abandoning or orphaning it. Second, the Commission determined that the ratio between the well's gross revenue and plugging, abandonment, remediation, and reclamation costs is an indicator of whether a well continues to be used or useful. All wells must be plugged, abandoned, and reclaimed pursuant to the Act and the Commission's rules. Some wells must also be remediated to clean up contamination or spills and releases. Thus, when the costs of conducting these required activities exceed the revenue actually generated by the well, it is a strong indicator that the well is no longer used or useful. The Commission recognizes that it is important to review gross revenue over time. Accordingly, it intends to consider a relevant time frame that factors in the remaining production from the well, if any. The Commission will also consider the operator's total number of wells and production from those wells over a recent time frame, likely the last 5 years. And finally, the Commission will consider an annual average of the operator's gross revenue over a 5-year period. The Commission would review the operator's gross revenue from the well in conjunction with the status of the operator's financial assurance of the well. Third, the Commission identified an operator's failure to use or develop a facility as an indication that the well is no longer used and that it may no longer be useful. Fourth, the Commission determined that the remaining economic viability is a factor that may indicate the used or usefulness of a well. The Commission recognizes that many varying factors determine the economic viability of a well, including price uncertainty and cost variability. Accordingly, the Commission will consider relevant financial evidence from the operator to help identify whether the well continues to be economically viable and ultimately used or useful. And finally, the Commission recognizes that other factors not listed in the 100 series definition of used and useful may also be relevant in determining whether a well is used or useful pursuant to Rule 211. Accordingly, in subpart E of the definition, the commission included a catch-all for other relevant evidence, which the commission recognizes may vary on a case-by-case basis. The elements of the definition of used or useful are intended to be the criteria for which the commission will weigh when determining whether a well and/or locations are no longer used or useful, and that a well or location closure hearing pursuant to Rule 503G12, initiated by the Director of Relevant Local Government, pursuant to Rule 211. The elements are also what the operator would be required to show as an affirmative defense in such hearing. The commission will entertain arguments from an operator about why a well or a location is indeed still used or useful based on the elements listed in the definition. So with that, and understanding how the rules that I was applying, the statement of basis and purpose that I was applying, and the definitions that I was applying, I want to indicate that I believe the applicant has met its burden of proof in that it is conferred in good faith with the operator and has certified that each of the subject wells have been low producing for each of the previous 3 years. As to the determination of whether there is a threat to public health, safety, welfare, the environment, or wildlife resources, and whether or not the wells are used or useful, my thoughts are as follows. Generally, my approach was to evaluate each well first to determine whether it is being used. In my opinion, the clearest way to determine this is to see if the well is actually in operation and is producing oil and/or gas. As indicated by the statement of basis and purpose, there are many reasons that a well may not be in operation, and for my analysis, I did not distinguish between any particular reason the well may not be in operation, but rather identified those wells that were not currently being used for further analysis as to their usefulness. I also believe it is reasonable to further evaluate those wells that may be occasionally or intermittently used and are producing at such low rates as to determine if they actually qualify as being used. There were some instances of this, and those wells also went on for further analysis as to their usefulness. For those wells that I had determined to be being used, there was no further analysis as to their used or usefulness, as it is my opinion that if it can be determined that they are being used, then they cannot be subject to plugging and abandonment under Rule 211 as it pertains to used or useful. Each of those wells that I had determined to be used did go on. Each of those wells that I determined to be used did go on for further analysis for reasonable and necessary protections for public health, safety, welfare, the environment, and wildlife resources. For those wells that I did not determine were being used, I went on to first evaluate them for their usefulness. As indicated in the definition of used or useful, there are 5 criteria to evaluate the usefulness of the subject wells, and those have been explained. So first, I'll give a perspective on how I evaluated each of the 5 items. For production trends of the wells, I looked to the SBP, which states the commission determined that the production trends are highly relevant in determining whether a well continues to be used or useful. Production is the primary and often only source of revenue from a well, therefore declining production over time or zero production is a strong indicator that the well is no longer used or useful, unquote. It is common knowledge that production declines over time, as all parties have indicated in this proceeding. It is also known that the wells in question are between 40 and 60 years old. So it is to be expected that the decline curve on these wells would be relatively steep and production would be significantly lower than earlier in the well's life. And while there may be some academic disagreements on the best way to characterize production trends, I believe the experience and expertise on this matter provided by the applicant by way of Ms. Lincioni provided a reasonable evaluation of production trends and decline curves, and that they met their burden for this evidence. It is important to note, however, that even if a well is at its low end of the production trend, does not mean, in my opinion, that it is not useful. The second item I reviewed is the plugging, abandonment, remediation, and reclamation costs in relation to the well's gross revenue generation. The commission was clear in the SBP that all wells must be plugged, abandoned, and reclaimed pursuant to the Act and the commission's rules. Some wells must also be remediated to clean up contamination or spills and releases. Thus, when the cost of conducting these required activity exceeds the revenue actually generated by the well, it is a strong indicator that the well is no longer used or useful. It is also clear to me that all of the elements included in this parse must be evaluated. That includes plugging and abandonment costs, remediation costs, and reclamation costs in relation to the well's gross revenue generation. So that is what I looked at and evaluated. There are many other expenses that were argued during this proceeding as having bearing on determining whether the subject wells were useful. I do believe these expenses speak to the economic viability of the wells, so should be considered as well. So I included the economic viability in my analysis under this section. While the operator does not include all of the possible expenses in their determination of expense, I think it is reasonable to utilize their number, which I rounded up to $400 per month per well, as an OpEx expense. I note that this does not include plugging and abandonment, remediation, or reclamation, which are required elements for evaluation. For plugging and abandonment expenses, which I note in the definition necessarily includes flow lines, I do not believe the amount provided by the operator is reasonable. I do believe it is reasonable to utilize the default amount determined by the commission in the financial assurance rulemaking as presented by the applicant, in lieu of reasonable evidence of demonstrated cost by the operator. So that is what I utilized in my evaluation. This default number does not include reclamation as well, so that would be included in the the default number does include reclamation as well, so that would be included in the $130,000 per well amount. Remediation is an essential expense to be evaluated. The applicant provided only ECMC staff's determination for field-wide estimates for remediation costs in 2023 as evidence for this expense. The operator did not provide any evidence of differing remediation costs and did not include remediation in their expense evaluation. As some time has passed since ECMC staff determined that number and some elements that determined that number have changed, I do not think it is reasonable to utilize that full amount. I do, however, believe that a number for remediation must be utilized in my evaluation. So I used 50% of the number utilized by the applicant, which amounted to approximately $286 per month. This is a very conservative number, as the majority of subject sites have direct remediation requirements that would likely dwarf the total of this number over 5 or 10 years. Financial assurance is to be evaluated against the expenses associated with plugging and abandonment, reclamation, and remediation. And in my evaluation, the financial assurance is not what could or should be provided by the operator, but rather what financial assurance ECMC currently holds for the operator. Generously, this comes out to approximately $1,000 per well. This should be subtracted from any expense evaluation associated with plugging and abandonment, reclamation, or remediation of the subject wells. Most of the subject wells are in need of an MIT test, so that expense also needs to be included in these calculations. I also looked at facilities as there are a couple contemplated in these proceedings. The SBP states the commission identified an operator's failure to use or develop a facility as an indication that the well or facility is no longer used and useful. And finally, I looked at other relevant evidence to determine usefulness and beneficial use. Items brought forward include fair market value, carbon capture and sequestration, deep geothermal, recompletions, and enhanced oil recovery. I do not believe that evidence provided on fair market value is relevant, as much of it did not pertain to the well or oil and gas operations as expected by the rules. I also seriously question any viability of the subject wells to be candidates for carbon capture and sequestration or deep geothermal due to both testimony provided by Ms. Lincioni proximity to homes, schools, and other sensitive receptors, and lack of concrete evidence provided by the operator on efforts to pursue these avenues. I also seriously question the viability of enhanced oil recovery and recompletions. While there may have been some recompletions done on 3 wells 20 years ago based on forms provided to ECMC at the time, no other records exist in ECMC databases or on other recompletions, and the operator provided no evidence to support their statements that they had been done. In addition, the analysis provided on the potential for recompletions appeared truncated and incomplete and is dated, so I discount its relevance. In addition, new rules regarding operations in proximity to sensitive receptors like homes and schools would make it questionable that in most cases on the subject wells that recompletions may be able to get permitted. So for these reasons, I did not consider these factors in determining whether the subject wells are useful. Finally, for those wells determined either used or useful, I evaluated each for whether it is reasonable and necessary to protect or minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources that would require plugging, abandonment, reclamation, and remediation. For me, this is a very high bar. ECMC is the regulating agency that is required to protect public health, safety, welfare, the environment, and wildlife resources, has processes and procedures for dealing with spills, releases, and violations of ECMC rules. In each of the subject wells with issues, ECMC has engaged these processes to work towards the proper cleanup of these sites. While there is certainly debate as to the quality of progress made by the operator on many of these sites, ECMC still has the enforcement tools available to it, up to and including the requiring plugging and abandonment of these sites to ensure the work gets complete. I evaluated each of the subject wells through the lens of whether or not it was reasonable and necessary to require the immediate plugging and abandonment, reclamation, and remediation of these sites, rather than letting ECMC processes and enforcement continue. Utilizing the aforementioned approach, I will share my conclusions on each of the subject wells. For those deemed used, it is because they in fact are currently being used and therefore meet the used requirement. For those deemed not used, as indicated before, I evaluated for usefulness. For those not deemed useful, it was determined first that they were not used and then determined that they in fact would have a negative cash flow after evaluating projected life of the well, prior production trends, operational expenses, and expenses of plugging, abandonment, remediation, and reclamation, including expense of required MITs, based against any projected revenue and current financial assurance of $1,000 per well. So with that, in the jurisdiction of Dacono, wells that I deemed used include the UPRR 43 Pan Am I number 5, the UPRR 43 Pan Am I number 24, the UPRR Pan Am I number 13, the Robert A. Hutchins number 2, the Robert A. Hutchins number 1, the Lepla Estate number 1, the Foreman Unit number 1, and the Firecracker Unit number 1. The wells that I deem no longer used and useful include the UPRR 43 Pan Am I3, the UPRR 43 Pan Am number 23, the UPRR 43 Pan Am number 16, the UPRR 43 Pan Am number 15, the Peltier number B1, the Peltier number 2, the James S. Haley Trustee B2, the Coslet A9, and the Coslet A4. For Frederick, those that I deem to be used are the Woolley number 2, the UPRR 42 Pan Am AE number 4, the UPRR 42 Pan Am number 1, the UPRR 42 number 3, the Champlin 86 Amoco B number 4, the Champlin 86 Amoco B number 2, the Champlin Amoco 86B number 5, and the Woolley Unit number 1. Those I deemed to be no longer used and useful were the Thomas Russell B number 2, the Thomas Russell D number 1, the Thomas Russell D number 2, the Grant number 4, the Grant Tank Battery Facility, the Grant number 1, the Max Serafini B number 1, the Max Serafini B number 3, the Arthur Stromquist number 1, the Milton Nelson F number 1, the Serafini B number 2, the Grant number 3, the Colorado National Bank number 1, the Morgan A number 2, the Morgan A number 4, the Walsh number 3, and the Walsh number 5. I did not find that any of the locations met the burden of reasonable or necessary for needing immediate plugging and abandonment action through Rule 211 for the protection of public health, safety, welfare, the environment, or wildlife resources. That is not to say that these sites do not need immediate and constant action taken to bring them into compliance with ECMC rules to ensure protection of public health, safety, welfare, the environment, or wildlife resources, but rather it is more reasonable and necessary for ECMC to continue to utilize all of the tools available to it to ensure that these sites are fully remediated to the high standards provided by the agency. And I encourage the commission to continue to use all tools available to it to ensure that this happens. So that is the conclusion of my comments. Thanks for giving me the time.
All right. Thanks for those comments as well. Commissioner Ackerman?
Thank you, Mr. Chair, and I really appreciate the work done here by Commissioners Cross and Messner. I have a lot of very similar comments. My comments were largely, although much more eloquently and completely stated by Commissioner Cross. I also wanted to reiterate that, my approach certainly is to be analytical and dispassionate in each case and each application that comes before us, thereby rendering a decision based simply on what I believe to be the best interpretation of existing law. Rule 211, as Commissioner Cross mentioned, he set forth the history, so I won't reiterate it, was converted from Rule 208. And I agree with his characterization of Rule 211, as well as Commissioner Messner's. I did want to reiterate, although it's been said a couple of times, that certainly it weighed heavily upon me in the basis and purpose that the Commission, quote, has rarely required operators to plug and abandon wells pursuant to Rule 208, and intends to continue exercising its discretion under Rule 211. Only in rare instances where doing so is necessary, not reasonable there, to protect or minimize adverse impacts to public health, safety, welfare, the environment, and wildlife resources. While much more is said in the basis purpose statement, I won't reiterate what's been said by the commissioners before me. And I'll skip down through my analysis of the rules, as all of my points were also addressed by either Commissioner Cross or Commissioner Messner. In the end, kind of summarizing those rules, well closure under Rule 211 is intentionally a self-imposed very high bar for the Commission. For me, in paramateria, I interpret this regulation being used rarely to mean that the Commission does not use the authority of 211 lightly, but will use it in circumstances where all other reasonable avenues have been exhausted and unsuccessful, including but not limited to enforcement efforts, and it then therefore becomes, quote, necessary to use it to protect public health, safety, welfare, the environment, wildlife resources. I had the same analysis that they had of the burden of proof associated with what must be presented and what must be complied with. I did want to add just a little further color to a couple of issues that were raised repeatedly and also addressed by Commissioner Cross and Commissioner Messner to a lesser extent, that I certainly have thoughts about, but want to make clear that I don't feel are significantly pertinent to the matter. And that's the constriction of development due to existing oil and gas leaseholds in a municipality, and the issue of developer-operator leasehold buyout agreements. On the constriction of development, to me, it's been clear that there's been some significant behind-the-scenes discussion between developers and local authorities regarding the difficulty of furthering residential and or commercial development in the area of these wells. And to be clear, I do not believe 211 applies for matters of inconvenience or development priority shifts, including restriction of other types of development. 211 focuses on the protection of public health, safety, welfare, the environment, and wildlife resources, and or wells being used and useful. And while I understand and empathize, as Commissioner Cross stated, with the conundrum that this is for the relevant local governments, I also recognize that the difficulties that developers face when attempting to develop on and around active oil and gas leases after a municipality has grown up around those leases. I don't view the 211 process as a vehicle for effecting well closures related to convenience or land use matters, and I accordingly did not include that specific consideration in my deliberations. To be clear, I do not want to create an avenue for those who want to use geographical locations for purposes other than properly permitted oil and gas to petition the commission and order wells to be closed for that purpose. I don't believe that's the intent of 211. That said, I want to note that while this issue came up multiple times, the relevant local governments specifically noted in their testimony that their application was not based on nor driven by this issue. With regard to the well closure agreements and buyouts, I'll skip some of what Commissioner Cross said, but wanted to make the point that in response to questioning, the operator testified that they do not consider this value when assessing the value of its wells. However, in closing arguments, the value was specifically called out as the remaining economic value, or at least one significant factor of the remaining economic value for the wells in question. I find this troubling. And for the record, I disagree that related transactions entered into and submitted as exhibits by the operator represent transactions that were free of encumbrances and undue stimulus in an open, unrestricted, and competitive market, and therefore establish, quote, fair market value for these wells. I don't believe they do. Rather, fair market value and therefore economic value under the used and useful regulation should be the value of the wells when used for their intended and permitted purpose, not the monetary figure associated with holdout type surface land buyouts. I found the relevant local government's argument under Garfield v. County Board of Equalization in 2013 to be compelling on this point, and I would agree that there was considerable undue stimulus in those transactions described and entered into exhibits by KPK. As the operator initially stated, they don't consider this value when assessing the value of their wells, and as I do not feel this is an appropriate metric for assessing economic value under the used or useful definition, I also did not consider this specific valuation metric as a legitimate remaining economic value for those wells. While the relevant local governments raised the issue of protection of public health, safety, and welfare in numerous and various ways, really the preponderance of the case in chief of the evidence that they submitted was focused on these wells no longer being used or useful. And a key tenet of the argument was based on work done by the relevant local government's expert, Ms. Lencioni, who concluded that none of the wells have gross revenues that exceed liabilities and therefore have no remaining economic viability, which is one consideration of determining whether wells are used and useful, as we've heard multiple times. They pointed out that Ms. Lencioni has done thousands of well valuation analyses, most often to substantiate bank financing or operator asset acquisition. And while this analysis is valuable, analysis prepared for bank financing or asset acquisition, in my opinion, may not incorporate the same factors, philosophy, decision-making, and level of economic risk as the costs of simple asset retention by a company who already owns those assets for future potential revenue income analysis. And I agree with Commissioner Cross on significant deficiencies associated also with KPK's financial analysis. But I find KPK's decline curve analysis at least to be more statistically valid from a pure statistics standpoint than the end-of-life assumptions of the relevant local government's expert witness, ignoring the fact that these wells are under mandatory closure orders, and would reiterate the validity of the operator's method of plotting based on actual data rather than data associated with clearly curtailed and or impeded well production. That said, taking years to remediate spills, remedy operational issues, and rectify procedural and administrative shortcomings certainly introduces doubt into whether these wells will ever produce at previous levels. And certainly the confidence interval goes down the longer that these wells are out of production. Which leads me to kind of reiterate a point also Commissioner Cross made about the surprising line of argument so often raised by the operator. represented by statements such as, just because we didn't do an MIT doesn't mean there's an integrity issue, or just because it just means we didn't submit a form, or just because we didn't submit a timely form doesn't mean we didn't take remedial action, or just because we didn't tell you about our flow lines doesn't mean we don't know where they are. I really find this line of reasoning to be, I like how Commissioner Cross put it, disreputable, but I find it to be detrimental to the point of the operator being a responsible operator in general. Schedule MITs obviously are required specifically to demonstrate the integrity of a wellbore. If one isn't done, it is true that it doesn't innately mean that the wellbore has lost integrity. However, such a test is required specifically so that ECMC can ensure a wellbore hasn't lost integrity, hence the need for a test. If I'm forced to speculate on whether an action was or was not taken in absence of a form, I would have to assume the action has not been taken until it's been affirmatively substantiated. In other words, if I, as a decision-making role, had to make a determination based solely upon the lack of required MIT, I would find it more prudent to assume that the lack of a scheduled MIT places a well's integrity in question, rather than in a position of drawing conclusion that everything is probably fine. The same logic follows for the operator's inaction, lack of attention to detail, and or failure to perform any required action or file any required form. In summary, the relevant local governments testified, among many other things, that in general, KPK has lots of issues. I would agree. Each time one is closed, two come up. That sure seems like things pop up very frequently with regard to KPK remediation issues. They testified that ECMC requirements are often disregarded and ignored by KPK. I would agree. This has come out in this hearing and in previous unrelated hearings. They testified that there are significant spills and more at KPK than other operators, largely at flow lines in significant numbers, especially in the last 6 years, and other operators act quickly to remedy such issues while KPK does not. Once again, I would agree. These are good points being made by the relevant local governments. Many of these are in subdivisions and near surface waters. They have open remediations with little or no progress towards closure. They don't communicate well. They're not complying with MIT testing requirements. They argued that wells shut in for more than 12 months should be plugged, and they're not. They argue that flow lines are everywhere, and this is their largest concern, and that they're largely identified. They worry about their lack of reporting, their lack of flow line testing, providing no information that KPK should provide. Commissioner Cross addressed gaps in production and the operator's response that there must be a simple problem downhole, but nothing's being done about it. So in general, to me, the relevant local governments argue that KPK's consistent and material violations, coupled with their financial condition, constitutes a threat. And these assert and constitute deficiencies and violations of varying nature, many of which have been the subject of past unrelated hearings, which have resulted in significant actions, as pointed out once again by my fellow commissioners, by this commission toward this operator, as well as current and ongoing legal actions. ECMC does not turn a blind eye to these deficiencies and violation, and is addressing them via other appropriate avenues and processes. This is an important protection for operators so that they do have due process moving forward. Admittedly, when an operator has significant and difficult issues, it seems to be a fight to the finish. Most often, these rules are intended to protect the rights of operators that are operating in good faith and quickly, as the relevant local governments have pointed out, others within their jurisdiction do. I agree that this operator must be more diligent in remediation, in operational and administrative work. KPK noted a number of times during these hearings that it's redirected significant resources to remediation endeavors in recent years. Yet it continues to acknowledge in various ways that it continues to run behind the curve or the norm or on even basic remediation work, the proper and timely submission of forms and other related work. And so to me, while these matters are significant and they're the subject of ongoing concern by me and ongoing and current actions by staff in this commission, a blanket closure order is indeed a request for very significant relief. Make no mistake about it. My position is that ECMC must continue to work within all other existing processes to ensure compliance on all fronts by this operator and allow all other judicial processes to play out, but that the evidence presented is not justification for blanket closures at this point. as the arguments don't substantially satisfy, in my opinion, the high burden of proof set forth under the purposefully narrow criteria and intended use of Rule 211, triggering the Commission's standard of exercising its discretion only in rare instances where doing so is necessary. So because the application was asking for blanket closure of multiple wells rather than an application for an individual well, my determination in end aligns with that request by finding the applicant did not meet the burden of proof to order closure of all of the requested wells under 211. That said, I also examined the submissions associated with each well. I find many of them to be in varying degrees of certainly decline and potentially end of life. I think that it would behoove all involved to continue to watch and continue to work on how these wells are appropriately and either used and useful or closed and plugged and abandoned, reclaimed and remediated. While I'm open to further discussion on Commissioner Cross's recommendation on UPPR 43 Pan Am I-25, Milton Nelson F1, Thomas Russell D2, my determination is that a blanket closure of these wells is not warranted under 211, and that we must allow all the other mechanisms to continue to work on these issues.
Thank you very much, Commissioner Ackerman. Appreciate those thoughts as well. Commissioner Oath, you power turned back on. I know you've been with us the whole time. Did you want to provide some perspective?
Yes, thank you. And I am very grateful to my fellow commissioners for articulating many reflections and thoughts and findings on a number of issues. I agree in many respects. I won't state all of the things I agree with, but I do just want to highlight a couple of things that I really also noted. You know, with respect to the user useful test, I think it's important to note that I too think that it is important to include plugging in, abandoning, and remediation costs in that analysis. I also agree with Commissioner Cross's comments that that potential future use arguments by KPK have not been shown, and I agree that potential future uses need to actually be possible, not just identified. With respect to MIT testing, I agree that agree with the testimony by staff in particular that MIT tests can be performed and should have been performed in this case, and that the failure on KPK's part to submit those reports and do the testing means that the sites have been unremediated for years, which is certainly very problematic. With respect to public health, safety, welfare, and the environment and threats to it, I disagree with KPK's argument that the threats must be, so significant or so severe to justify in order to plug and abandon. That is not the standard in the regulation or in our rules. With respect to ongoing enforcement actions, I too would recognize that I understand very much the relevant local government's frustration with the pace of the ongoing enforcement processes. In my analysis, I would say at a very high level, I have heard a lot of evidence in this hearing that leaves me with significant concerns about the way that this operator is conducting business here in Colorado. I think the evidence in the record shows them to be chronically non-compliant and recalcitrant and coming back into compliance and operating in accordance with our rules. And overall, I was persuaded and did find that the way in which they are conducting operations does present a threat to public health, safety, and welfare. I was not persuaded by KPK's testimony on this point with respect to potential risk analyses by the EPA. I found that to be overly generalized and inapplicable in this proceeding, and did find that the city and town's witnesses on this topic to be credible and persuasive. And so in general, do find that these wells are operated in a way that present a threat. That said, I too am troubled by the other part of our rules, and we do need to follow our rules, of course. And so am not able to find that the action being requested here in this 211 proceeding to permanently close the wells is necessary in order to address those threats. I don't like that conclusion. But it is really important that we stay true to our rules. And, I wanted to respond to a comment in the relevant local government's closing that, this could potentially send a message to other operators that this conduct is acceptable. And I don't think that is a takeaway or the case here. I think, as other commissioners have noted, there are numerous and significant enforcement pathways that are the appropriate tool to address these types of noncompliance and conduct. And I am aware of and am convinced that this agency has done and continues to do everything possible under those tools to hold this operator responsible for noncompliance and achieve remediation at these sites as quickly as possible. In the event that this commission prevails on a number of those actions, it's my understanding that KPK may cease to operate all wells in Colorado, not just the subject wells. And so I know that I too am frustrated that that proceeding continues to play out. But I think that is where we are. In the event that those enforcement pathways that are currently pending are not successful, I think that I, as one commissioner, may find the outcome of this analysis a bit different. But for now, that is where I am on public health, safety, welfare, and the environment portion of the test. As for used or useful, I can be very brief on this topic. I appreciate commissioners' comments and deliberative comments and being very specific and thorough on this topic prior to me, because it leaves me in the position to be able to say that I find that there is sufficient evidence in the record to support closure for the wells that have been identified by Commissioners Cross and Messner for the reasons that have been stated. So that is all I have. Thank you, Mr. Chair.
All right. Thank you to my fellow commissioners. Sometimes it's nice to go last. I appreciate and understand everything that people have said. I'm in agreement that the 211 and the necessariness of plugging and abandoning to ensure protection of public health, safety, welfare for the environment and wildlife has not been met. I am sympathetic to the city and town's position. I also am reading the rule, I think, as we wanted it to be read, which is that it is rare to be used. The precedent we have in using it has much more significant immediate threats to public health and welfare. And while KPK as an operator is negligent and does a poor job and doesn't get things cleaned up and is recalcitrant and doesn't file forms and doesn't do MITs, I do not find that the burden of proof was met that it is necessary to close these wells in order to protect public health, safety, welfare, and the environment. So with that, and sort of looking at my notes from what everybody has said, I believe that myself, Commissioner Oath, and Commissioner Ackerman would deny the requested relief for the reasons as articulated. Commissioner Cross, I think you would deny except as to 3. Is that right?
It is, but I think I understood, and Commissioner Oath, I don't want to speak for you, but I think I understood that she also would find at least some of the wells also no longer useful.
Correct. All of the wells that were identified by Commissioners Cross and Messner, I believe that there's sufficient evidence in the record to support closure of those wells.
Okay, so that's
No longer
the
used or useful.
Commissioner Messner identified 9 in Frederick and 17 in Dacono, or maybe that's backwards. Anyway, I think our hearings manager Thomas was keeping track of all that. AG Davenport, maybe I'll ask you to visualize as well, since we're in kind of a strange place in terms of what next steps might look like. So maybe if my summary is that Commissioner Ackerman and I would deny the relief, and then the other three commissioners would uphold the relief, but as to a subset of wells. Maybe that's the better way of saying it.
I believe that's accurate, Chair. We do need to get to a consensus of at least 3 commissioners on
Okay, so let me
some measure of relief.
Yeah, let me put it this way. So we've got 2 commissioners that would deny as to all. We've got 1 commissioners that would deny except as to 3. And then we've got 2 commissioners that would deny a greater subset beyond just the 3 articulated by Cross. Is that accurate? If anybody,
That's the way I understand it.
Okay. So maybe an easier way to ask this question, and not to put you on the spot, Commissioner Cross, but did you, having listened to Commissioner Messner, did you feel a change in terms of where you were to add additional wells to the list? And I'm not trying to pick on you. I'm just trying to see if we've got 3 that are in the same place.
No, and I understand the question, and as I'm looking here, I see one of mine also did not match on it, and I'm wondering if even though it was talked about throughout the remainder of the testimony, I'm wondering if it was one of the ones that was pulled out later on, the 125, because I didn't see 125 on Commissioner Messner's list either, the UPRR.
Commissioner
Messner? 25 is on there. I actually, when I typed it from my notes, I put 24 instead of 25.
Okay. I wondered if I was just perhaps.
Here's the difference, though, is that I actually have UPR 43 Pan Am I-25 as used.
Being used, yeah.
Not and so therefore find it to be used versus my other 17 that I indicated I determined to be not used or useful. And so we really only have agreement on 2 for not being used or useful.
Yeah. And I guess big picture, I completely understand and where Commissioner Messner came down from on a lot of that analysis as well. I think that the main points of difference for me is, as I expressed during it, I have a hard time granting the used simply because there is some production going on. Because as I noted, especially, and I think that's a good one to look at, under the decline curve analysis provided by KPK here, there's no value to the UPR Pan Am 43 125. I think I got that number right. Even with the assumptions that they provide, and as noted, I think by all of us, I think there are some concerns both ways with a lot of the cost assumptions, lease operating expense assumptions going back and forth. And so I have concerns with saying just because a well is producing something, even if it's producing little, being used, I don't know that while under the plain language, I think that is consistent with the rules. I think when you look at what the statement of basis and purpose says, I think it clarifies some of that ambiguity, as operators would simply be able to prevent and avoid that plugging and abandoning liability simply by having 1 barrel of oil every month or 1 barrel of oil every few months, and that would be sufficient. And this could go on for years and years, that you could have a situation where well really isn't useful, well's losing money, but maybe they're hoping to keep it in the hopes that someone's going to pay them down the road to plug and abandon it, rather than them actually taking the steps to properly operate a well that is, I don't even want to say marginally producing, because it's actually losing money and has the potential to be a threat to public health, safety, welfare, environment, and wildlife resources by the continued operation as such. So while I do understand where Commissioner Messner is coming from on that used language, and that's one of the things that I disagreed with, only because I think that we have to look beyond that used language to used or useful, to try and make sense of how Rule 211 is meant to be used. Because otherwise it could, in the same way that I think the future beneficial use could easily avoid 211 liability just by saying we could use it as a giant flagpole. And like that's a future use. I think that grandiose ideas without supported evidence are not sufficient to show future beneficial use. I think in the same way, without any kind of evidence to show that the value of revenue from that well exceeds the costs as stated in the statement of basis and purpose, does not necessarily mean it's used. With respect to the other ones, I think this is something we can definitely talk about. I'd have to do a little more digging into each of the different wells there, because I think fundamentally, again, I understand where Commissioner Messner came down from on his evaluation of the valuations and looking to Ms. Lencioni's costs and taking into account, I know you talked about some conservative estimates of using half of it. I didn't do that analysis initially, so I've been trying to take some notes and look at some of those, as I think one of the things for me is where there is at least some value under KPK's assumptions, recognizing the concerns with those assumptions. I at least consider those useful wells, and I think some of those fell into the category that Commissioner Messner identified as no longer useful because taking into account some of the other assumptions might go the other way. And so I think potentially, but I'd have to do a little bit more digging into some of those well by well, which is why I was trying to take as many notes as I was during the deliberations.
All right. So Commissioner Cross, if I understand you correctly, you're still in the place you originally were, unless and until you had some more time to look at the wells that Commissioner Messner has identified.
Yes. Yeah. And I think again, I think the key difference is I think there was numerous wells that even under KPK's assumptions were just barely profitable, at least for the next couple of years. And I know, looking at least a few of them, some of those wells definitely fit into the same category of, well, they do have some profit, maybe just next year or the first year production is brought back, maybe for the next couple. But so I think a couple of those are obvious. I was obviously very much on the fence for anyway. But I know at least for some of them, I've been trying to look back at some of the information on those as well.
Okay. Well, let me try this and we'll see where this goes. I would move that the requests for closure or plugging and abandoning under Rule 211 are denied, except for the 3 wells articulated and determined from Commissioner Cross's deliberations. Just trying something on for size. Do we have a second? Commissioner Ackerman?
Thank you, Mr. Chair. I'll second your motion. I think this discussion we're having right now and this motion really illustrates the complexity and difficulty of a blanket request by an entity for closure. I believe that the 211 process was intended to be more of a precise approach when there is a well that has taken into account all of our processes, all of our enforcement issues, all of our actions, and still can, be substantially substantiated that it's a threat to public health, safety, welfare, the environment, and meets the definition of no longer used or useful. As we're having this discussion, and they're all great points, and we saw the disparity in discussion between certainly the operator and the relevant local governments. that I think we really could have significant discussions about each of these wells individually at a much more detailed level. My concern remains that this opens an avenue for an expectation that people can bring groups of wells to us when I believe that the intent was for a more precise approach. And so I'll second that motion, but with some trepidation of diving into individual wells rather than answering the question as asked, which is, should we close these wells?
No, I appreciate those deliberations, the second first and the deliberations second. And your point is precisely the reason that I felt it was important to make the motion, because of the difficulties inherent with this. And I agree. I want the message to be sent that Rule 211 is a rare situation and should be more individualized uses used in the future. So we have a motion and a second. We have ton opportunities for deliberation. Commissioner Messner, and then Commissioner Oath, and then Commissioner Cross. Maybe I'll call on you last.
So a couple things. I think I would prefer to see the three individual wells have individual emotions because, um, as much as I have heard Commissioner Cross and, understand why he thinks that the UPRR 43 Pan Am I number 25 is no longer used and useful. To be consistent with how I applied things, I would not be able to determine that in my analysis as not used or useful. I have it as being used. And I'll acknowledge that I did bifurcate the evaluation of that to first determine whether it was used or not. That didn't mean that I didn't further evaluate what was used with the combination of used and useful on those close situations. But generally speaking, if it was currently being used, there was some benefit of the doubt of it being used and under production, irregardless of the cost analysis, in my determination of used and useful versus if they're not being used, then the evaluation of usefulness did necessarily take into consideration remediation, reclamation, plugging and abandonment costs, MIT costs, OpEx costs, the gamut of things that we were required to evaluate as part of this on an individual well basis. And if it's not being used, then the usefulness has to be evaluated on an individual well basis. And all of those things have to be evaluated and applied. And so as I did that evaluation, that's how I came up with the list of wells that were no longer used and useful by pretty literally interpreting the rule as I see it should have been interpreted. And so just to explain to you, Commissioner Cross, a little further how I was getting to where I was getting. And so Chair Robbins, because of the way that I analyzed it and how I'm applying the rule, I would request that it at least go in two motions, if not three individual motions for the wells that Commissioner Cross is talking about, or has brought forward. I don't know, Commissioner Cross, if you need additional time to think about or look at things, but I think it's reasonable to take the time necessary in order to be able to apply the rules as you see fit. And so I think that's your discretion and would be open to any consideration that you might need for additional time or not. So.
All right. Thank you for those deliberative thoughts, Commissioner Messner. Commissioner Oath.
Thanks. I had raised my hand because I was not sure, given where I am, how to vote on the motion as articulated, because while I would support closure of a more expansive list, I wouldn't want to vote no on a motion that supports closure of those and have the record reflect that inaccurately. So I was just trying to figure out what that means for my position. I think if we did do separate votes, that could clarify that issue for me. So that could be a path forward.
Okay. Thank you for that, Commissioner Cross.
Thank you, Mr. Chair, and thank you, Commissioner Messner. I do understand where you're coming from on that, and um, I think your discussion of the kind of the benefit of the doubt on the used is in a lot of the same ways. Some of the way I looked at some of my economic analysis with respect to some of the close ones. If they were somewhat close, I maybe gave them a benefit of doubt, even if there was only a year or two of runway. To continue to at least operate those to make some of their money towards making back some of their plugging liabilities, remediation liabilities, et cetera. So I think I had kind of done the benefit of the doubt as well, but maybe with respect to a different area there. I think that said, I certainly am willing to do the individual motion on those three, understanding where Commissioner Messner went from. I'd be happy to look at more detail on some of the valuation on some of those close ones. Although I will say I do agree with Commissioner Ackerman and Chair Robbins that I hope that I made clear in my deliberative comments. I too am concerned with creating a precedent where we get a lot of these motions with people trying to say, I don't think they're making money on this, or I think that this needs to be plugged. It's been shut in, it's not being used, and trying to encourage 211 motions from being brought more consistently than what they have been. As the statement of basis and purpose says, it was meant to be in rare instances. And I do think that this is, at least for some of these wells, fitting. And I do think that for such a unique application to be brought, I do think that this is one of the better instances. As Commissioner Ackerman said, I think the sheer number, and as I think I said in my initial deliberations, I think the sheer number may have muddied the water a little bit in terms of trying to break down the user useful as well as the reasonable and necessary to protect or minimize adverse impacts. So my initial thought was, yes, I think I'd be willing to vote on the three immediately. I'd be happy to spend some more time doing some additional analysis on some of the additional ones that Commissioner Messner did, but I think I'd also have to look at the used and useful a little bit more as well. So my initial thought would be I'd probably still stick to the three to try and keep it to a minimum, but
Okay, let me suggest this. I'm the movement, Commissioner Ackerman is the second. I would amend my motion that we move to deny closure or 211 on all wells except for the three articulated by Commissioner Cross. And just to show you where I would like to go, we then would take up each of those wells on three different votes, but it gets rid of the whole subset, but those three. So that's and I think I can amend my motion. Is that right, AG Davenport?
Yes, you can with the permission of the second.
Commissioner Ackerman.
Yeah, I'm okay with that. Thanks, Chair.
Okay, we now have a motion and a second to deny the relief requested, except as to the three wells identified by Commissioner Cross. If this motion is successful, we'll then take up those three one at a time. Is there further deliberation on the motion and second? All right, let's do a roll call. Mr. Thomas?
Commissioner Ackerman,
Yes.
Commissioner Cross,
Yes.
Commissioner Messner,
No.
Commissioner Oath,
No.
Commissioner Robbins.
Yes.
Mr. Chair, that motion passes 3-2.
Okay. And I hope the 102 people understand the difficulties that the commission has in making difficult decisions. Okay, Commissioner Cross, could I ask you to make each motion sequentially with regard to the identified wells that remain at play?
Certainly. And so I guess I can do the motion. I'd first move for requiring plugging and abandonment pursuant to Rule 211A with respect to and I'll do the contested one first, the UPRR 43 Pan Am 125, which is in Dakota.
Second. Further discussion on that motion? Commissioner Ackerman?
Thanks, Mr. Chair. I'm going to be voting in favor of all three of these motions. I will beat the dead horse here and essentially say I don't think that bringing groups of wells is an appropriate use of 211. That said, I did do an individual analysis, as did my fellow commissioners, and I found all three of these wells to certainly be within the realm of warranting closure. One would hope that closure would move towards an acceptance and an execution by the operator. But in the end, they certainly do, I think, meet the bar for closure. So while my argument was that we should deny the relief because I don't feel it's appropriate to bring groups of wells under 211, in considering each of these in their individual capacity, I do feel in favor of closure.
Thank you for that. A.G. Davenport, if you could show back up, I have a clarifying question. Apologies for this back and forth. The applicants in requesting closure, I believe in their requested relief, wanted closure to occur within 1 year. Did I recall that testimony correctly?
Sorry, I was trying to unmute.
And I guess my follow-up question is, do we need to insert a time frame?
It may be helpful to insert a time frame. Without a time frame, well, I'm stating the obvious here, but without a time frame, there's no time frame.
Yeah. Do any of my fellow commissioners recall Stephen Lewis's Prescott's relief request on that?
Could we state as proposed by the applicant?
Oh, that's elegant.
If we don't know what was proposed, then
I see Commissioner Cross is staring at a screen.
Yeah.
I'm going back and looking at my notes as well.
In the application, I'm just seeing immediately.
Yeah. My notes reflect order to be plugged within 12 months.
Okay. Yeah, and in the application itself, I'm seeing immediately plugged and abandoned and reclaimed.
I mean, I don't know if my notes are correct, but that's what I typed down in the closing from Mr. Stephen Lewis Prescott. Do you want to amend your motion, Commissioner Cross?
I'd be happy to. I'd be happy to amend it to pursuant to Rule 211A, plug and abandon and perform any necessary remediation and reclamation. Understanding the reclamation may take longer, but plug and abandon remediate within 12 months the UPRR Pan Am 43-1-25 in Dakota.
And I will amend my second. Is there further discussion on this particular motion? Mr. Thomas, roll call.
Commissioner Ackerman,
Yes.
Commissioner Cross,
Yes.
Commissioner Mesner,
No.
Commissioner Oath,
Yes.
Commissioner Robbins.
Yes.
Mr. Chair, that motion passes 4-1.
Commissioner Cross, second motion.
I would move pursuant to Rule 211A, the plugging and abandonment and remediation within 12 months and the necessary reclamation of the Milton Nelson F1 well in Frederick.
Again, I will second. Further discussion on that motion? Roll call, Mr. Thomas?
Commissioner Ackerman,
Yes.
Commissioner Cross,
Yes.
Commissioner Mesner,
Yes.
Commissioner Oath,
Yes.
Commissioner Robbins.
Yes.
Mr. Chair, that motion passes 5-0.
And the final motion, Commissioner Cross?
I would move for plugging and abandonment and remediation within 12 months pursuant to Rule 211A and any necessary subsequent reclamation of the Thomas Russell D2 in Frederick.
Finally, again, a second. Further discussion? Roll call, Mr. Thomas?
Commissioner Ackerman,
Yes.
Commissioner Cross,
Yes.
Commissioner Mesner,
Yes.
Commissioner Oath,
Yes.
Commissioner Robbins.
Yes.
Mr. Chair, that motion passes 5-0.
Okay, thank you very much. My fellow commissioners, I truly appreciate the dedication from all of you. The articulated rationales was really well done, despite the fact that sometimes they weren't quite on board with each other. And as I mentioned earlier, I think this is reflective of the difficultiness of applying Rule 211 in this fashion. I do believe we've come to a acceptable result on this. The hearings officer will put an order together that will be binding upon the applicant consistent with the votes that we've had today. Is there anything further for us this afternoon? Seeing none, I would move to adjourn.
Second.
All those in favor signify by saying aye.
Aye.
Aye. Any opposed? We're adjourned. Thank you very much.